Can a first-time DUI affect your immigration status? Yes, it can. If you're facing a DUI charge, but for example, caused injury to a third party, such as you caused an accident, the accident was due to your driving under the influence, and the people on the other vehicle or even your own passengers resulted in some sort of harm or injury, that can be determined to be a crime of moral turpitude for immigration purposes and can place your immigration status in jeopardy. Can any drug charge affect your immigration status? Yes, it can. Controlled substances are one of those issues for immigration that are very, very harmful for status. If you are not a U.S. citizen, a simple possession as a lawful permanent resident or even a person without any status in the country can lead to your removal from the United States. So is there a way of avoiding immigration trouble while pleading or negotiating a criminal resolution? As part of our procedure in our office, it is to always be informed of what the immigration status is of our clients. And we inform them that it's not because we are going to disclose it to third parties, but we need to know what their immigration status is so that we can better protect their rights. So what is the difference between facing a charge in criminal court versus immigration court? Criminal court is usually a state court. Unless you're facing federal charges, then it is a federal court. But normally, something happened, it occurred within the jurisdiction of a state, and then you will be facing criminal charges in that state. Immigration court is considered federal jurisdiction, and so therefore you will be in an administrative federal court. So an example of how a criminal charge for controlled substance can affect your immigration status. Lawful permanent resident for 7 years, was caught with some controlled substance in their possession. The amount was substantial to the point that it was initially charged with possession of controlled substance with intent to sell. We knew that the person was a lawful permanent resident and that should he plead to that charge, that it would impede any form of waiver or relief and ultimately would lose his residency. So we were able to negotiate it to a simple possession without mention of the controlled substance. What this does, it gives them leeway to be able to, because he was a resident for more than 7 years, to be able to file for a waiver in immigration court and, if granted, be able to remain in the United States lawfully. If you have any questions with regards to how your DUI or drug possession case might affect your immigration status, please call Confianza Legal for a free consultation.